All right, we're going to begin. Thank you, everybody, for joining us today. We're here to discuss the legal framework of token issuance in a non-regulated and regulated form. We'll start our webinar with a brief introduction to our speakers, and then I'll hand over the stage to Jonathan. At the end, we'll also do a short Q&A to wrap everything up. So if you have any questions, feel free to shoot them down and drop them into the Q&A section below, and we will get to them at the end. I'm joined here now by Jonathan Klinger. Hello, Jonathan.
Hi, how are you?
I'm great. How are you doing?
I'm amazing.
Great.
Thanks.
Jonathan Klinger is an Israeli cyber law attorney and blogger, acting as legal consultant for several high-tech companies and startups. He is legal counsel for Hamakor, Eshnaf, People for Intelligent Internet Use, Israel's Digital Rights Movement, and many other organizations. Jonathan taught computer game development law, as well as media law at Beit Baruch College, and volunteers at the Digital Rights Movement's free speech clinic, where he takes cases relating to strategic lawsuits against public participation. Welcome, Jonathan.
Welcome, and thank you for inviting me. Do you want me to share my screen, or do you want to do it from your screen instead?
That would be great.
Okay, so I'll share my window. You need to stop your screen sharing so I can share it.
All right.
Okay, so thank you, and we'll begin the presentation by discussing what do we call tokens anyways. Because we're discussing tokens, we need to understand what is a token, what isn't a token, because a token has many meanings in different frameworks, either legal or technological, and it's sometimes used in the wrong way. So the first thing we need to understand is that a token is a digital representation of something. It doesn't have to be of money or of value, but it is a digital representation of something that we use. Now, this means that it's somewhat cryptographic, meaning using technology to encrypt it and to make sure it is unique. It could be a file, a digitally signed file. It could be a digitally signed asset on a blockchain, but it can have a lot of other different representations. Now, the next thing we have to discuss is what is a security, because there are two meanings for security. The first is a security in the sense of an asset, a security that could be either an investment agreement, a share, a bond, stock, or anything similar to that. And the second is security in terms of information security, the way that you keep things secure. While these use the same word as a semantic, they might get mixed up when you use them. And because of that, we'll have a full slide on how security affects security and the definitions of what security actually is or might be when you do it. This means that
Jonathan, I'm going to pause just for a second because your screen, if you're able to just reshare the screen or maybe go into a full screen again. Parts of the presentation are being cut off.
Let's see what happens if I do that. Yeah, you can see me that now?
Yeah, that's great.
Okay.
Continue.
So a security could be either information security and technology, or as I see it, it could also be the other option, a stock, a share, a bond. So for that, we will have a full representation later on. The next thing is to ask, what do we call tokens actually? What is it? Oh, sorry. Because do we have to use cryptocurrency? Meaning, is cryptocurrency or crypto-based blockchains necessary for tokenization? And the answer is no. You can use either encryption to create cryptographic tokens like we have on our payment cards, the small chip that you use for payments on your Visa card, or you can use other forms of digital issuance. However, most cases deal with the issuance of cryptocurrencies or tokens on a specific blockchain and assets based on that. And this is why we have to make sure that security, the way that we keep those tokens secure, will affect the security, the way that we deal with them as a unit of value. So why do you want a volatile token? Meaning, why do you want a token that value will go up and down? And the answer is not that certain. Not all tokens are volatile. There are some tokens like the Israeli Kalu, which have a fixed unit. There are stable coins. We'll discuss them in a future sense. But a lot of people issue tokens to make profit from their initial allocation or allotment. And that's why they want their tokens value to change. Now, there are some tokens that are pure investment tokens. They're pure speculation on the ability of a specific technology to be advanced. Let's say Bitcoin. The price of Bitcoin currently does not represent anything but people's future trust in the ability of the Bitcoin blockchain to provide people with a safe payment system. Because of that, because there's no real stable transaction environment, um, for Bitcoin, then the value of Bitcoin represents future expectation and future risk. Unlike Bitcoin, the future of Ethereum, for example, already represents the added value existing in the current technology. So some assets are merely representing a pure investment now, expectation for something to be added in the future, and some do have intrinsic or current value. There are some cases where each token is like a snowflake. They have their own unique value and properties. In cryptographic tokens, such as information security tokens, some tokens will have different signatures. They will be signed by a person which represents their identity. They will have different forms, like if you know how CryptoKitties work, which is a good example for tokens that are unique. Each kitten's properties is derived from the token itself. So in order to understand what is security in the economical and legal perspective, we need to understand the Howey test. Howey is a US Supreme Court case from the 1940s that involved the issuance of a specific agreement. There was quite a lot of land in Florida that was sold to people, and the sale was attached to another agreement. The agreement said that the group of people who manages the property will work the field and will grow oranges on those lands. And the profits from the oranges later on grown and sold will be distributed between people. This means that there is an agreement to make um, use of the land and that all future revenues from the land will be shared between people. The SEC decided that this is a regulated security. This is an investment mechanism. And because it is an investment mechanism, it is subject to securities laws, meaning that you cannot make uh, an issuance, an allocation without a prospectus. You have to undergo underwriting. You have to undergo uh, uh, disclosure of all risks. You have to go through all the proper legal channels and list your security in the stock exchange. This is quite an expensive process that is meant to protect investors. Now, in the future, in the next few slides, we'll go and explain exactly why Howey was considered a security. But we also need to understand that security laws are here to protect investors from cases where they're exposed to fraud, cases like we see in pyramid schemes or in other investment tools that are meant to deceive investors, even though that the intentions were clear and honest. A lot of these places, transparency and protection helps. So the first definition of a security is something that is issued in a series. Not all investments will be a securities. For example, if I have a building, an apartment complex, and I sell each apartment for different price. I negotiate each of them with different terms for different buyers. This is not a series of issued tokens. This is not a series of issued securities, but different transactions. So the first thing is that it has to be issued in a series. It has to be issued for more than 30 different people in identical notes and identical agreements representing the rights and the obligations, even if the price itself is different. The second is that it has to notify right of membership or a claim. It means that the use of the paper or the token has to represent some kind of an ownership, a stake, a joint venture, a revenue, or some legal claim that I can bring using this paper. This means that if my token or if my agreement doesn't give me any future right, but it's mere description or documentation of a donation, then it cannot be a security. It also has to represent investment of money, either cash or cash equivalent, meaning that if the tokens are not issued for the payment of some money, but are granted as acknowledgement of some achievement or are granted for people's um, activity that was done without any relation to the project or is done randomly or without any other compensation, airdrops, which we might have time to discuss, then this might not be deemed as a security later on. The security's value has to derive from a common enterprise, from something that's not unique to the rights attached to the agreement. If we go back to the apartment complex, the rent from each apartment comes from the owner's efforts. He publishes the apartment on Craigslist. He goes and he finds the tenant. He shares the revenues later on with his family members, and the money comes from his enterprise. On the other hand, if I buy stock in a management company that receives payments from tenants, then the money I get from dividends in that stock represent the enterprise and the efforts of the company and the other people, and not just myself. The next issue is that there has to be some expectation of profit. If there's no way to make money from this investment, if it's a mere donation, then it is not a security. Now, expectation of profit doesn't have to say that the agreement says that the note will bear interest. It also doesn't have to say that the agreement says that all investments will be profitable in the future, but it does have to show that people reading the investment documents, people going over the prospectus, and people trying to figure out what to do will have some kind of expectation of profit here. Now, the profit has to derive from the efforts of others. Again, if we go to the apartment complex, if the profits in the apartment go from my work, then it's not a security. But if they go from other people's work, if someone else is in charge of advertising the complex, if someone else is in charge of finding the cleaner, if someone else is in charge of collecting the money, and I just sit and passively see my profits, then it's derived from the profits of others. Now, all of these criteria, when met, create something which is called an investment agreement. Usually, it's enough that one of them won't exist in order for the agreement not to be deemed as a security later on. However, it is not the safe thing to do because, as we'll see later on in the presentation, when people tried to nullify only one or two of these pillars, the SEC, the Securities and Exchange Commission for the US, found out that even though they didn't explicitly say something, then it could be later deduced. So the best thing you can do is make sure that at least half of these pillars won't exist, if not more. So the problem is that even though these laws have been in place for almost a century and people are aware of these laws, lawyers know what to do, then people try to circumvent the law and find ways to make sure that their clients will later on have to pay fines to the SEC by trying to nullify only one pillar or change only one thing. And this causes something that is problematic: uncertainty. As a lawyer, we do not like uncertainty. We want things to be as certain as possible so we can make sure that our client's future is safe. A lot of people during the hype that started in late 2017, the ICO, SAFs, and other uh, forms of token issuance hype, tried to do the best to sell shovels, to sell services to the people who tried to say take token issuance and to make a lot of money from it, and not to give them the best advice. This is what caused a lot of these projects to fail, because they relied too much on the stage where they raise the capital and not enough on the stage where they develop an actual product. So the profits were from hypes, from pumps and dumps, and not from the actual products. As we'll see, if you have a good project, you can make a lot of money even without the token sale event itself. So the first thing, which I'm not sure that lawyers were actually involved, was the Satoshidice case. Eric Voorhees, one of the main participants in the Bitcoin community, even back then, had an online casino that was based on Bitcoin and allowed people to gamble on the next block. This was called Satoshi Dice. It was so profitable, first of all, because the results were based, if I'm not mistaken, on the Bitcoin block itself, and therefore they were validated. This means that they gave certainty that the casino doesn't cheat. So Voorhees had a really profitable casino, and he decided to sell shares in his casino on a forum. He said to people, well, if you just pay me to this Bitcoin address, I'll send you back profits in the future. This all worked so fine for a few months, and then Voorhees found a purchaser who purchased the casino. When they purchased the casino, then Voorhees paid the people who bought the shares. He paid them their investment and some premium, and went on. It took some years for this to catch on, and the Securities and Exchange Commission went after Voorhees for this endeavor and fined him a few tens of thousands of dollars. Voorhees paid a fine. Currently, he's one of the founders of Shapeshift and very involved in the blockchain community. But this was the first case of an actual ICO, the offering for people to get some kind of value and some kind of participation in a blockchain project. Then around late 2017 came the hype of the ICO. The initial coin offerings were either the establishment of a new blockchain or use of the Ethereum blockchain to issue tokens, where there was a huge pre-sale. Most of these things went under the following legal framework. There's a nonprofit association that will provide you later on some kind of token, and it will provide you that token based on your gracious donation to that nonprofit, and by no means based on your purchase of tokens. Now, the people who develop the project are not affiliated with the nonprofit. They're the workers and employees in some kind of third party company, which is also paid by these tokens, and the remainder of tokens are held by the nonprofit. This construction of a legal framework was kind of problematic. The first is because it was obvious to all that this was fictional. The nonprofits were managed by the same people as the for-profits. The donation had to be proportional to the tokens issued later on, and everything in that framework was a real problem. Now, if we understand this, we also understand why the profits here were also fictional. People were ensured that there's only a limited supply of tokens and that the future value of these tokens will increase because there is a limited supply of the tokens and a constant rise in demand. Now, this caused people to understand one thing: profitability is insured. This means that there's an expectation of profit. It also means that the profit is not derived from your own investment, but from the investment of others. Now, once these tokens are tradable, this means that this is indeed a security and this is indeed regulated under securities laws. Now, in order to avoid this, people tried to issue another form of investment. They called it SAFT, Simple Agreement for Future Tokens. The SAFT ensured people that only a limited number of participants, what we call in legal language accredited investors, will be able to participate in that sale. Because of that, then securities laws do not apply. The US securities laws does not apply to people who are high net worth over a few $1,000,000 because they are smarter, because they know the market, they know how to operate, and therefore they are not subject and they do not need the same protections that the government provides all the rest of the people. Now, this was, of course, a big fiction. Why? Because if you only buy these tokens now and you sell them later on to a person who's not an accredited investor, or these are listed in some sort of exchange where anyone can buy them, then all the claims that we made before of being able to be a security device, an instrument that allows people to profit, return. And therefore, the whole fiction that was staffed in order not to be subject to securities laws was also acknowledged to be a problem and to be a security. Then came the IEOs, the initial exchange offering, which carry the same problems as before, but they are regulated by the exchanges themselves, meaning the exchange check that everyone who participates is indeed regulated and is indeed an accredited investor. Now, there's a problem here because once the tokens are released to the public and they can use them on their own wallets, again, they can trade them either through another platform that is not regulated and does not check that the tokens are only sold to accredited investors, or through other channels, such as switching the ownership of that account. So again, as I see it in the near future, we will have a SEC ruling that these IEOs are also security. So another form of uh, fiction was the utility token. The utility token was an attempt to claim that if some token has a real life value in a real life situation, in a real life environment, then it's not a security because people use it to pay for things. Now, if you read the recent Telegram ruling, you'll learn that that is again wrong because if something is a utility token and there's a limited number of tokens, again, you raise the expectation for people that this will be profitable in the future. If, on the other hand, the utility token has a vending machine where anyone can buy another token because there's no rationale for having a limited supply of tokens, then it might not be a security. But in that case, we all know that utility prices go down over time. Electricity becomes cheaper as technology evolves. Storage becomes cheaper. Computing power becomes cheaper. So if my token represents a utility, computer power, storage, or something similar, its price should go down over time and not be an investment. So let's have a look at a few things that might work or did work, and how they could be implemented later on in your own projects. The first is to have a stable coin, a fixed value token. If your token has a fixed value, then it's not an investment mechanism because it cannot have people expect to see a profit from. Um, for example, if we look at Tether, which tethers itself to the US dollar price, then Tether by itself is not an investment device because it represents one US dollar. And if you want to invest in dollars, you can always buy dollars. You don't have to buy Tether. Tether is a payment mechanism. The same goes for uh, stable coins that will be attached to a physical specific property. If we see diamonds or gold or something like that, that their value is derived from the physical representation that they have. However, if you issue fixed value tokens that are attached to fixed property, then people won't try to invest in your project because, well, they can just buy the real thing in most cases. The second thing is issuing your tokens only for people who contribute to your community and project. Let's say that you have, for example, a community that is people who are interested in knitting or sewing. So you have a token which represents, let's say, the ability to organize community events or the ability to pay for someone else's time. If this token comes from the other people's um, appreciation of your work and only from things you did benevolently, then it might not be a token. If you want a good example, you can see Reddit's gold, which only is usable inside Reddit. It allows you two things. It allows you to grant the gold to others, meaning if someone wrote something funny, you can tip him, or to buy ad-free services of Reddit inside the community. So this is something that's community-based and cannot be a security because it has nothing outside the community. Another way to say that your token is not a security is if your entire project is decentralized, meaning the ability to issue new tokens is based on something which is decentralized and there is no one entity that controls the issuance of tokens. The SEC um, um, referenced this when they had a talk about Ethereum. They explained that because Ethereum, even though it had some pre-mine, is currently decentralized and the project has a lot of contributors and the issuance of new tokens is based on mining, then they don't see it as a security. Now, the problem is that all of the projects that I referenced aren't profitable from the token issuance themselves. They say, well, if I want to have this project, I'll have to create an ecosystem that people will use. I have to create a good product. And yeah, we're trying to find people who do good products and create something of value and not just pump some hype in order to get money. So um, we can see that you can attach some kind of right to your token if it's not a security. If we go back to Reddit's Gold, Reddit Gold can buy you ad-free use of the Reddit network, and maybe some people will exchange that Reddit Gold for services, theoretically. So if you do that, theoretically, you are in the clear. Um, a token also, if you grant it based on someone's contribution, let's say they released some code into your GitHub repository, then the token later on could be used to buy some computing power in the project. It could be traded between people, but it cannot be issued for payment by the main development team. Another thing you can attach to a token is the right to vote in a nonprofit Git repository or community project, meaning that the more tokens you have, the more control you have on some kind of nonprofit endeavor. For example, if I'll have a civil rights coin which represents $1,000 donation to the Association for the Advancement of Civil Rights, then any one token would represent one vote in the vote on which case should we take pro bono in our legal clinic. Now, this is okay because I don't profit from it directly. In brackets, as long as I'm not the guy in the pro bono case just buying the representation in that way, which would be kind of unprofitable. Now, you can also attach to your token a physical unique item. This could be a bar of gold or an apartment, but if you look at Nine Inch Nails, well, they sold a digital download of their album, and because they like the physical world so much, they attached a block of chalk roll, which is a physical representation of your music. Now, you can add some physical item to your token, which represents the token represents ownership of, and then the trading of the token will be the trading of that item, which leads us to the ERC 777 revolution. If we go back to CryptoKitties, we understand that we can create tokens where each token's unique properties will be reflected in the code, meaning that the token's property could say color of eyes, height, width, plot of land. If I have, let's say, a big farm and I want to distribute all the trees in my farm to people and tell them each one of you gets ownership of a tree, each of the ERC 777s could represent a specific tree. Now, this is where security meets security. If my token is a digital representation of a physical product, or if my token represents ownership of something which is more than the token, let's say my token represents my access token to my email account, which is something you can do. Anyone whose wallet holds this virtual token will have access to that email account, or anyone who possesses this token can come to the store and redeem this specific bottle of whiskey. Then, if you don't secure your tokens in the right way, meaning you don't grant security, then you might be liable for securities fraud or security violations later on, meaning that if your exchange that does an IEO and your tokens are later stolen, then once they're traded, it's your responsibility because you did not secure them enough and you allowed these securities to be traded openly. So securing your tokens allows you to create legal certainty if you have more security. And that's the pun. Now, we'll go into some don'ts, which is lessons that we learned from others. The first major don't, and this is the biggest don't you can remember and leave the seminar with, is don't offer people profits in your projects. Never say that your token represents some kind of right in future profits in that project. This is the biggest no-no that you need to remember, and people forget that. The second thing is if your token's value can fluctuate, and if you go and do a SAFT or something similar, an IEO, don't allow your token to be traded. Once tokens are traded, then they are regulated. Now, if you're the guy who's issuing the tokens, and the tokens are not a community project, allowing them to be listed in some kind of exchange means that your tokens value might change over time and that people will either deduce that there's an implied statement of profitability or try to do something to the value of your token. If your token could have a specific value attached to it for the rest of time, it is best. The next thing is don't allow the tokens a vote in a for-profit project. I know I said a few slides ago in your nonprofit, a vote is great, but once it goes to a for-profit, it represents some rights that are attached to a share. if you go and buy a share online or someone else, your share represents not only the right to receive future dividends, but also the right to vote on the future of the company. And this is one of the rights that is attached to a security. Interestingly enough, there are enough shares that could be voting only and not distributing value, and they will be also an investment device. Now, we'll go over a few examples, or three, before we head to the Q&A to explain and understand where the regulator intervened and why. The first is Munchie. Munchie was an ICO that sold tokens for a service that allowed people to rate restaurants. Now, while by itself it doesn't sound that profitable or interesting, you have to remember 3 years ago, a big hype. Anyone would invest in anything if it was blockchain related. Now, Munchie was fined by the SEC and stopped their project, mostly because their white paper, the prospectus and website, said to people, because we have a limited amount of tokens, you can expect that the price will rise as demand rises, which we see in a lot of projects that have a limited amount of tokens. Now, this statement by itself means that even if you got all the other things right, if you only did a SAFT, if you only went for accredited investor, once you had this obligation, people realized that they might have more money or this is profitable, and the thing will be deemed as a security. The next, which is still pending in court, is Kik. Kik, the popular messaging app, tried to do a great thing, which is to create an ecosystem based on its own messenger where people can pay for things using the KIN token. The KIN token was some kind of currency Kik developed. It was blockchain based and it was traded. And this is where the problem came. If Kik by itself only had a vending machine where people could buy these tokens and use them inside the ecosystem or later on even cash out, then I don't think that the SEC would interfere. But because they did so, Kik started a whole legal process, and the case is still pending. There's hundreds of $millions at stake, and I hope Kik will win. But when the US regulator comes and puts his foot down, it's quite hard to fight it. Now, the other example is Telegram, who recently lost a preliminary injunction in the New York District Court. Telegram decided 2 years ago to issue the Gram token. The Gram was supposed to be the payment method for the Telegram network, where people bought in a pre-sale the Telegram tokens. And the SEC decided that they want to challenge this in court. Last month, the court ruled in favor of the SEC, saying that because of two major reasons. The first is that the tokens are to be listed on exchanges, and because Telegram offers people automatic profit because they have a buyback mechanism and a limited number of tokens, then they believe that the Gram token is some form of security and should be regulated under security laws. And they issued an injunction barring the operation of the TON network, the Telegram network by itself. Now, thank you very much. We'll move to the Q&A section.
Yeah, thank you, Jonathan. This is a super fascinating topic, and I'm so glad that we got the time to cover all of this today. The topic that we covered here require deeper discussion, and we're grateful that you could take the time to flesh them out for us. So thank you. Now I'd like to take the opportunity to open the floor to our attendees. Anyone who might have a question, feel free to drop it in the Q&A box below or in the chat section. That works too if you can't find the Q&A box. And we'll start with the first one that we have here. Just for Jonathan, in your talk, you mentioned the US regulation. Which countries outside the US should we consider looking into securities and cryptocurrencies in terms of their current legal status?
So this is a big problem. I'm talking about U.S. law. Actually, Israeli law is almost identical in that sense. But people just say, okay, well, we'll bar the U.S. participants from our ICO and all will be fine. Now, this is a problem, first of all, because it's not correct. Even if you do your know your customer and you don't sell in the initial sale to U.S. customers, the U.S. Regulators could get jurisdiction even only if one person from the U.S. bought it on a secondary market. So, right, there are other jurisdictions in Europe that have some kind of regulation for the issuance of tokens. Most of them have something that might be responsible. The Gibraltar regulation for distributed ledger technologies is quite interesting and allows you to do some kind of token issuance, or the Maltese one. Even if you go to the UK ICO regulations, however, the US government tends to carry its long hand globally. So it doesn't matter where you sit in the world, even if you try to close your first allocation to US customers, as long as some US citizen could put his hands over your tokens, they'll go after you. So if you want something that's comfortable, either do it only localized, only for a specific country with specific intent. For example, if you want to do a specific project for Barbados that has a token that is usable only if you're physically in Barbados, then the Barbadian jurisdiction will apply. But if you have some project that's used worldwide, I know it's really hard to adapt to all security regulations globally. You should try to be as much as adherent to US regulation as possible, even if you bar US citizens.
Great. Thank you. We have another question here. What is the trend in the US towards new tokenization projects in terms of legal and regulation aspect? What would we need to look out for over the next 3 to 4 years?
So if you can have a look on my slides, I think it was slide 1 to 30, and go back and listen. But generally, the trend is that the SEC always is one step behind in litigation, but is quite vigilant. It's not that these things go in dark markets. Now, people try to have a more regulated atmosphere of their projects. You can also see people try to use things like a token which is attached to a real share that's really traded in an exchange, or tokens that are attached to some kind of land plot or things like that. But if you can attach your token to some kind of regulated asset that is regulated already, either in the US or in some other market, then you might have a digital representation of that asset that might be later tradable. I think that Spice VC had something similar. You can have a look at their website. They tried to establish an investment venture capital firm that represents its investment with tokens. I last heard of them a year ago. I don't know if they've done any new investments, but that would be something that could tag along and be implemented later on.
Okay, great. Thank you. I have another question here, guys. If you have questions, feel free to drop them in the Q&A section. Why would anyone invest in a token priced always at $1?
Well, there are a few reasons. Let's say that currently you live in Venezuela and you have your internal inflation of the Bolivar at, let's say, 20% a day. Then if your token is attached to the US dollar and you can't buy real dollars, then investing in something that keeps its value is a great thing. Another thing is if your bank has negative interest on saving. Today, we're not just in a world where oil prices are below zero. We have interest rates below zero in some countries. Germany, Denmark, if I'm not mistaken. If you want to open up a savings account, they will charge you money for managing your saving account. Now, if you invest in something that is fixed on value and your saving account costs you 0.1% per year, then you made 0.1% by keeping your value and not having less. Now, this is right if your state is currently deflationary. It is right if it's harder to maintain the physical asset. Let's say that I have a suitcase filled with gold bars. Now, keeping those gold bars secure will cost me money. I have to buy a safe to my house. I have to buy some kind of alarm system. I have to pay for insurance. If I have some tokens that I can store on my ledger device and represent ownership of these gold bars, then, well, maybe it's cheaper to keep safe, it's cheaper to insure, and it's cheaper to trade later on. So these are reasons to invest in things even though their value doesn't go up in the future.
All right, and we have one last question here, and then we're going to wrap everything up. What are the main assets you see going towards tokenization and digitization in the future?
Well, once we get the corona pandemic done, I think that the first thing we'll see is tokenization of tickets, meaning, let's say, theater tickets or airplane tickets or even train tickets. If today I want to sell a ticket in the used market, then I can do it in a few methods. The first is, well, I'll get a PDF file to my email. I just forward it to someone. Now, that someone doesn't know if I forward it to two people or just to him. And he doesn't know that it's not a fake ticket because even someone could just forge the PDF and create something else. So if the ticket was tokenized and colored coins or Ethereum allows that already, then you can theoretically tokenize the ticket and make it tradable. I can scalp tickets, I can sell it, or I can buy it as a present to friends, and I can trade them later on. This will go for trade tickets, theater tickets, concerts, anything else. The same for keys to your apartment. Let's say that you're an Airbnb client and you want to give someone the ability to open an apartment when he comes, but this should be first limited in time, and second, only after they've done an extensive Q&A section and an extensive know your customer procedure. So I can send him the token, and then he's sure that when he has the token, he's the only one who's able to open up the apartment, and the landlord can't go in because only the token opens up the apartment. So this might be tokenized as well.
Very interesting. Actually, we have one more question, and I think I'm going to shoot it at you.
Mhm.
One of our participants is asking, hi, what would be the main legal challenges in issuing a diamond-backed token? And PS, maybe you mixed the ERC 777 and ERC 721.
Yeah, I think I got the 777 instead of 721. You're right.
Thank you, Noah.
Yeah. And I think that if you want to issue diamonds, the biggest challenge is that diamonds are regulated by themselves. So diamonds have different regulations as gems, both for their authenticity and trading and taxes. And if you tokenize them, then you'll have a lot of problems that don't exist if you have only diamonds. The first would be the question of how you pay taxes. I know that in Israel, the tax on profits from selling and buying diamonds is something that is based on your turnover and not on your profits. And if you'll tokenize them and you'll sell the token at a profit, you might have to pay capital gains tax. So the mere tokenization will create a different form of tax regime. So if you want to go and tokenize diamonds, you'll first have to find some way to authenticate them and to make sure that everything goes right. But you'll also have to find a way that your tokens will later on be not taxed in a different way than the diamonds themselves, which is kind of the incentive of trading diamonds.
Yeah, the last webinar we had, we dived deep into this topic of physical assets. So with that, I'm going to say thank you to everyone for joining us today, and thank you to our speaker, Jonathan Klinger, and we hope you're all staying safe and healthy at home. We look forward to hosting many more discussions like these, and you're welcome to stay updated on upcoming webinars via Hub Security's LinkedIn and Twitter page. And you can also check out Hub's weekly digest on Medium for the latest stories coming out of the blockchain, cloud, and crypto sphere. Thank you so much, Jonathan, for joining us today.
Thank you for inviting me.
Of course, and we look forward to seeing you guys at some of our upcoming discussions.